But Atty. Cayosa, we'd just like to know, pagka ganito, sa inhibition, di ba? And you're asking a person to inhibit, it is a decision on the part of the justice in this case, di ba? It is when you say inhibition, it is a decision on the part of the official, di ba? Ganun lang po ba yan? Pakiusap lang po ba yan?
No, it depends on the grounds upon which you ask for inhibition. If it is any of those grounds mentioned in the Code of Judicial Conduct, Rule 3.12, or in the Rules of Court, Rule 137, these are mandatory grounds. So if it's any one of those, then the judge has to inhibit himself. But if it's not one of those, then it depends on the sound discretion of the judge for good and valid reasons or reasonable grounds. He may voluntarily inhibit himself.
Okay. So in this particular case, based on what you understand of the petition of Mr. Marcos, is there legitimate, solid ground for Justice Leonen to inhibit?
The four grounds mentioned in the petition for them to request inhibition by Justice Leonen, unfortunately, is not one of those mandatory grounds for inhibition. Therefore, it will depend upon the sound discretion of Justice Leonen whether or not he will inhibit himself.
Okay, what are the mandatory grounds again? Just to be clear about this.
Well, under Rule 137 of the Rules of Court, one is pecuniary interest, no? Meron siyang interest diyan sa financial or material interest in the case. Another one is relationship. If the judge or the justice is related within the sixth civil degree of relationship to the parties, or within the fourth civil degree of relationship with the counsel, ay hindi naman, no? And the other one is prior engagement as counsel, administrator, etc. in the case, which is not the case. The other one is the justice or the judge was the judge in an earlier case, which is being reviewed by the judge or the court now. But in this case, ito naman PEP. So, diretso sa Supreme Court. Idagdag natin yan, dun yung Code of Conduct of Judicial Officials, yung Rule 3.12, in addition to those mentioned in Rule 137, yung personal interest of family members of the justice or of the judge. In this case, wala namang allegation na ganon. And then lastly, if the judge or the justice has personal knowledge of evidentiary matters, wala rin naman. So if you look at all of these mandatory grounds for mandatory inhibition in the Code of Judicial Conduct and in the Rules of Court, yung apat na binabanggit nila, hindi napapaloob doon. That's why we go now to the sound discretion of the justice concerned.
Okay, since this is the PET, of course, it's still the Supreme Court, but they're deciding on something that is, they might argue, that is political in nature. It's not really like any of those cases usually handled by the court, no? Is it possible that you can argue on political bias? Because in essence, that's what they're driving at, right? That Justice Leonen is politically biased against them.
Well, only Justice Leonen will decide that under the rules and under the law. So it is his address to his own discretion. If he believes he can be an impartial justice here, then he can continue to be the ponente of the case. Of course, if you look at Rule 3.1.12, it says that no judge will take part in a case where his impartiality might reasonably be questioned. But then what is reasonably, under the circumstances now, will be dependent upon the assessment and the judgment of Justice Leonen.